Good afternoon, everybody. Or if you're joining us from the US, good morning and welcome and thank you for coming on this Fox-Williams webinar. It's our annual data protection update, and it's hard to believe that it's the third anniversary of the GDPR because so much has happened in the intervening period, not least Brexit, COVID and Schrems 2. So my name is Nigel Miller and I'm one of the partners in our tech and data protection group. I'm very pleased to be joined by Kolvin, one of the other partners in our team, who I'm delighted to say rejoined Fox-Williams last year, having left us for a few years to be in a US law firm. So great to have Kolvin back on the team. And also on our panel today is Ben Nolan, one of the associates in our data protection team. So here's what we're going to be covering today. Very of the moment, COVID-19. Kolvin's going to be looking at best practice for returning to the workplace. Then Ben will update us on the increasingly complex area of international data transfers and the new standard contractual clauses. I'm then going to look at the current position on cookies and similar technologies and the new eprivacy regulation. And then back to Ben for a look at recent regulatory actions and fines and what we can learn from them. So although there's a lot of detail in each of these issues, within this hour, we're going to keep the webinar fairly high level. Please do submit questions on the chat, but we have a lot of people on the call and we may not have time to address them all. So please do contact us afterwards if you need any more information or help. This webinar is being recorded and we will circulate a copy of the slides and also a link to the recording. So there's no need to try and furiously scribble notes if you don't want to. So first, if I may, handing over to Kolvin to look at COVID-19 and best practice for returning to the workplace.
Great, thanks Nigel, and afternoon everyone, or morning if you're joining from the US. So Boris Johnson has signalled that the work from home guidance will be lifted on June 21st. So while not everyone will be rushing back to the office, I think we can start to expect more office-based working and a push by most companies to encourage their employees to spend at least some of their time in the office. So whilst we're in a different situation to where we were probably 9 months ago when people started to return to the office, in terms of the pandemic, it's still a threat. And I think there seems to be weekly news of new strains and uncertainty as to whether the current vaccines will be able to immunize us against these new strains. So there is still a threat in terms of the pandemic, and there are a myriad of issues to consider when returning to the office, from employment relations to health and safety, and of course, privacy. So I'm going to look briefly at some of the overarching key issues from a privacy perspective in terms of managing the return to the office, setting out some practical actions, and a few frequently asked questions that we're dealing with on a regular basis. So firstly, looking at the key principles, one of the main issues to highlight is that in managing sort of return to work and COVID-19 concerns, there's an inevitable processing of health data. And that's really important to recognize because health data is subject to more stringent obligations under the GDPR. And health data can include things like COVID symptoms, so whether someone has a cough or loss of taste or loss of smell or a high temperature, vaccination records, COVID test results, and that's the case whether the results are positive or negative, because even if they're negative, they do tell you something about someone's health, and temperature test results. So that was quite popular in the autumn when people started their return to work. So it's important that you recognize that you are collecting more sensitive information so you can actually take appropriate action. So in terms of some of the key principles that you need to think about, now these are enshrined in the GDPR. I've not covered all of them here, but really the most relevant to the sorts of issues relating to dealing with a pandemic and returning to work. So these are called the data protection principles. So the first one is around data minimization. So this is really about keeping the data you collect to a minimum. So you should only be collecting information, and that includes health data, that you only need to take the measures required to keep staff safe. So no more than that. So in some cases, some information only needs to be held for a short period of time. So there's no need to create a permanent record. Transparency. So it's very important to be transparent with your employees. Again, this is a key data protection principle under the GDPR. Employees have a right to know how their information will be handled, so what you collect and how you use it. And it's important to note that some employees may be affected by some of the measures you intend to implement. For example, staff may not be able to work. So you need to be mindful of this and make sure you tell people how and why you wish to use their personal information, including what the implications will be. You should also let employees know who you will share their information with and how long you intend to keep it. There are also some general information that you need to disclose in terms of where you store the data and how you keep it secure. And on the note of security, that's a fundamental data protection principle under the GDPR, and it's particularly important in relation to health data. You have to keep people's information secure, and sort of related to that is delete it when you no longer need it. So given that the information is more sensitive, there are more stringent obligations in terms of keeping information secure. So you should really be considering additional security measures, things like stricter access controls. So making sure that only people who need to have access to the data have access, and password protecting the records, so that in case that if someone does stumble across them, that they can't automatically get access to the data. Encryption, that's very important from a privacy perspective, making sure that the data is encrypted at rest and also potentially when it's being shared. And things like read-only access and additional training, particularly for those employees that are handling this type of information. Another key principle under the GDPR is in relation to staff rights. So organizations must inform individuals about their rights in relation to personal data, such as the right of access, the right of rectification, and staff must be given the opportunity to exercise those rights and discuss any concerns they have with their employers. Proportionality and fairness, also a fundamental principle under the GDPR. You need to really make sure that any measures that you implement to deal with the return to work and managing the pandemic are proportionate to what you're trying to achieve. So you really need to consider whether the measures that you are looking to implement are intrusive, and if they're intrusive, see if there is some way to make them as least intrusive as they could possibly be. Also, if you're making decisions about your staff based on health information, you need to make sure that your approach is fair. So think carefully about the impact that your policy might have on staff, and make sure that it doesn't cause any kind of discrimination. So considering these principles and how you turn these into practical actions, Jess, if we could turn to the next slide. So the key kind of practical actions and recommendations that you need to be taking: firstly, provide a supplemental COVID-19 privacy notice. So that really deals with your obligations under transparency, and making sure that employees really know about these new uses of data. I would suggest it's best to create a separate notice rather than sort of hard code it into your existing employee privacy notice. So at the moment, you'll have an existing privacy notice to satisfy any data you're processing now as an employer. It will be best in the context of COVID to keep that separate, because hopefully the situation is only temporary. I mentioned before that where you don't need to, you should not be creating a permanent record. So I think a good example of this is in relation to test results. So think very carefully about the data you're collecting and actually whether you need to retain it permanently. When staff are collecting information from employees, it's really important to make sure that they're not over collecting, and also the employees that are sharing the information, make sure that they're not oversharing, because there is, I think, a risk in this particular scenario to sometimes over collect or overshare. So for example, when a line manager or maybe someone in HR is collecting information about someone's COVID symptoms, they don't necessarily need to collect the precise symptoms. You don't need to know that someone has a high temperature, or they've lost their taste, or they've lost their smell, or they've got a continuous cough. That information is not really relevant. I think all you would need to collect and ultimately record is the fact that someone has COVID-19. Similarly, if there are concerns about an employee returning to the office because their daughter has severe chronic asthma, that is not the sort of information that you would need to collect. All you would need to collect is the fact that there is a family member who is critically vulnerable. And so I think it's important to give some guidance and perhaps training to staff around making sure that in this particular scenario, people aren't, one, over collecting and oversharing. And that's really related to thinking about how you record information that you're told. Because in the context of the example I've given in relation to an employee's daughter with severe asthma, again, you don't need to record that. All you need to record is the fact that a family member is critically vulnerable. One of the sort of key requirements under the GDPR would be to carry out a legitimate interest assessment. So this is an assessment that balances your employees' rights against your rights as an organisation to use the data. And this is really important because it forms the legal justification for your use of the data. Given that the nature of the data you're collecting is health data, you need to think about implementing higher standards in relation to the collection and processing of that data. So one of the things that you'll need to do is have in place the oddly titled appropriate policy document. So that's actually a legal requirement to have in place an appropriate policy document when you're processing health data for employment purposes. And that's needed to really set out your legal justification for using health data. That's a specific UK requirement. It's not something that you'll find generally in the EU GDPR. It's something that is specific to the UK, but that is something that you need to have in place. Consider the enhanced security measures that you'll need to have in place to process health data. I've mentioned stricter access controls, password protected records, encryptions, and read-only access. And then also consider what additional training is required to staff for staff to handle this sensitive data, particularly HR staff. Lastly, you need to think about carrying out a data protection impact assessment. So this is an assessment that identifies any privacy risks associated with any new activity you'll be undertaking in relation to the measures that you put in place relating to return to work. So this identifies particular privacy risks, and also you're supposed to document any mitigating actions that you need to take in order to address those privacy risks. So there's a legal requirement to carry out a DPIA where you're processing significant amounts of health data. So that could potentially be an issue depending on exactly what measures you're undertaking. But in any event, this is something that is required as or should be considered as a matter of good practice. Okay, so turning to the next slide, Jess, please. So I've just set out here some of the regular questions that we get from clients relating to their return to work measures. So one of the most frequent questions that people ask is, can we test our employees for COVID-19? The short answer is yes, but it would need to be necessary and proportionate. And so you would need to be able to justify it for health and safety reasons. So if you think you need to test your employees in order to safeguard employees for health and safety reasons, then that would be, potentially permissible, but you would need to carry out a legitimate interest assessment and also data protection impact assessment. I think we need to consider that as the rollout of the vaccination program continues and we get effective and widespread and effective immunity through our community, it may become harder to justify any kind of COVID-19 testing or even temperature testing. Another question we get asked a lot is, can we make testing mandatory? I think that's really difficult to justify, and also there's some issues that would need to be considered from an employment law perspective as to whether it is lawful. And I think if it's unlawful from an employment or health and safety perspective, then it's going to be unlawful from a privacy perspective as well. Can we use the government's workplace testing program? So the government have a program in place where I think you needed to sign up before April, but ultimately they will supply you with testing kits for your employees to test for COVID-19. Again, I think you need to be able to justify the use of this program. Is it really necessary for you to carry out an extensive testing program in order to keep people safe? So you would need to go through the process of carrying out a legitimate interest assessment and a data protection impact assessment in order to verify that testing program is justified. It's also worth noting that if you do use that program, you will owe certain obligations to the government around sharing certain data with them, and you'll need to set up processes and protocols to share data with government. And also they push down certain responsibilities to you, particularly around informing individuals, encouraging individuals to report using the government COVID-19 app and the track and trace program, and also obtaining consent. Next slide, please, Jess. So another question we get asked regularly is, do I need to ask for consent in using the health data of my employees? The short answer to this is no. You do not need to ask for consent. And in fact, actually, we generally recommend that you don't ask for consent, because it's very hard to obtain valid consent from employees. But you do need a legal basis to use health data. And we would recommend what's called the legitimate interest ground, and it's in that context that you need to carry out a legitimate interest assessment. And then, given that it's health data, you also need a further justification, which you should be able to rely on the fact that this is really to protect employees at work, so it satisfies your obligations around health and safety. Can we collect contact tracing data? No, unless you have a legal obligation to collect this data. So that's something that organizations in the hospitality sector do. If you don't have a legal obligation to retain this data, you shouldn't really be collecting it just in case. Clearly, you need to distinguish that from a situation where someone has tested positive for COVID-19 and you need to identify certain contacts. But what you shouldn't be doing is collecting data in just in case someone may test positive in the future. So can I collect data on vaccinations of my employees? Again, yes, you can do that, although your reason must be clear and compelling. So one scenario in which that may be the case is if, as a result of someone's job role, they carry out international travel and you're booking that, it may be that you need to retain some kind of vaccination record in order to for that employee to travel and in order for you to book their travel. Another scenario, which I think is probably less relevant to most people on this webinar, will be if, for example, you have staff who are at the front line in terms of health and treating people for COVID-19. In that case, you may have a justification for maintaining vaccination records. If you have no clear identified specified use for this information and are recording it just in case, or you feel it's something you would like to know, then you're really unlikely to be able to justify collecting it. You really have to have a clear need for maintaining vaccination records. And of course, if you are collecting this data, you need to make sure that you are using it for legitimate purposes and to avoid using it to discriminate in some way. So I think next slide, Jess. And I'm now going to hand over to Ben, who will talk to you about international transfers and Schrems 2.
Thanks, Kolvin. So as Nigel alluded to at the beginning of the presentation, the last year has been quite eventful in the world of international data transfers, and there's been quite a few significant changes that have taken place. Without doubt, the biggest change that's taken place has stemmed from the Schrems 2 ruling of the European Court of Justice, and the decision was issued in July last year, and this is what we'll spend the most time on in this section. The Schrems 2 case itself has been pretty well documented by this stage, so I won't go into details of the facts, but from a legal perspective, there were two main consequences. So firstly, invalidated the EU-US privacy shield as a transfer mechanism, and secondly, the bit that we're going to focus on, the European Court upheld the validity of the standard contractual clauses, but only with major conditions attached, with the court ruling that organisations that are relying on the standard contractual clauses need to carry out a transfer impact assessment to assess whether they ensure an equivalent level of protection for the data that's transferred under them. And if not, then the parties need to adopt supplementary measures to ensure that level of protection. So in the months following the Schrems 2 decision, we were all sort of scrambling about trying to make sense of it and figure out what's meant by transfer impact assessment and supplementary measures. Thankfully, in November time last year, the European Data Protection Board issued some draft guidance on these matters. So firstly, taking transfer impact assessments, what's involved with these? Well, the European Data Protection Board says that a transfer impact assessment essentially amounts to carrying out a review of the relevant laws and customs which apply in the country of the data importer, and assessing whether these would prevent the standard contractual clauses from working properly. This represents quite a significant undertaking for data exporters, obviously, because usually they won't have any presence in the country that they're sending the data to, and they'll probably not have any experience of the laws that apply there either. As a result, the European Data Protection Board suggests that data exporters and data importers should work together when carrying out a transfer impact assessment. And that may seem realistic for the large data importers with deep pockets, such as the likes of Microsoft and Amazon. It seems slightly less realistic for smaller data importers that might be receiving data sort of on an ad hoc basis. So yeah, we're still trying to guide companies through that, and you may find some resistance in terms of the company that you're transferring the data to. In terms of the relevant laws which data importers and exporters should be looking out for, the EDPB highlights a few sort of positive and negative indicators to be taken into account, but by far the issue that's given the most attention are the public surveillance laws that apply in the third country, and whether these go beyond what is necessary and are excessive. This isn't really surprising because in the Schrems 2 case, the European Court sort of focused on the excessive nature of US surveillance laws when discussing transfer impact assessments and also the Privacy Shield. So to assist data exporters carry out a review of the surveillance laws in place in the country of the data importer, the European Data Protection Board has also produced some separate guidelines called the European Essential Guarantees, and they set out the relevant criteria you should be looking at when evaluating surveillance laws in place in the third country. Once the parties have completed a transfer impact assessment, the data exporter needs to document this. And if the transfer impact assessment shows that the standard contractual clauses would not be enough on their own to ensure an equivalent level of protection for the transferred data, then supplementary measures need to be adopted by the parties. In terms of what supplementary measures you can adopt, well, the EDPB's guidance essentially sets out three broad types of measures. There's technical measures, contractual measures, and organizational measures. Technical measures are probably the most important category of supplementary measures, as these are the only ones that the European Data Protection Board considers can protect against excessive surveillance laws in the country of the data importer. And examples of types of technical measures include strong encryption, and also pseudonymization of the data prior to it being transferred. Contractual measures are essentially what they say on the tin, is the parties including additional obligations in their respective contracts in relation to the data that's being transferred. So for example, you could have additional clauses around data subject rights and how the data importer will help individuals exercise these. Organizational measures are particularly relevant in the context of intra-group transfers, and they refer to things such as having in place group-wide policies to deal with access requests received from public authorities, for example. Whilst the European Data Protection Board's guidance is helpful to an extent, it provides limited assistance for parties that need to transfer personal data to countries that are deemed to have excessive surveillance laws, and that would include the US. The guidance effectively says that it won't usually be possible for parties to transfer data to these types of countries in a clear form anyway. So that means in a sort of human readable format. And that's really unhelpful because usually if you're transferring data to someone, the recipient of the data will need to be able to access it in clear form to be able to achieve their purposes in relation to receiving the data. So we're kind of hoping that the ICO will issue more practical guidance on this in due course, but that's yet to be seen. And notwithstanding this, in the meantime, organisations should still be carrying out a review of the transfers they carry out and the lawful mechanisms they rely on for making those transfers, carrying out transfer impact assessments to the extent that they rely on standard contractual clauses, and where appropriate, putting in place supplementary measures to provide additional protection for the data that's being transferred. So moving on to the next slide, another significant development in the past year relates to the publication of the new standard contractual clauses. And these have been prepared by the European Commission, and a draft were published in November time last year. And these are designed to replace the existing standard contractual clauses, which are a bit outdated and predate the GDPR. So the draft standard contractual clauses that have been issued by the Commission, they've been quite heavily scrutinised and also criticised a bit by the European Data Protection Board. So I suspect that they will change a bit over time. But some of the key notable differences from the existing SCCs include the fact that they cover a broader range of transfer scenarios. So currently the existing standard contractual clauses only cover controller to controller and controller to processor transfers. The new standard contractual clauses will also cover processor to sub-processor transfers and processor to controller transfers. And that's important because those types of transfers have essentially been a bit of a grey area since the GDPR came into force in 2018. Another significant change is that the new SCCs can be used by non-EU entities, which is pretty important now that the GDPR has extraterritorial reach, and meaning that non-EU companies can be caught by it. And finally, the new SCCs also take into account the Schrems II ruling and notably require the parties to carry out a transfer impact assessment prior to entering into them. So it's expected that the draft clauses will be finalised in the coming weeks, and once approved, organisations that are currently transferring personal data on the basis of the existing SCCs will have 1 year to transition to the new clauses. However, there's a bit of a spanner in the works for UK companies, and that's because the ICO has recently announced that it's working on a new set of bespoke standard contractual clauses for the UK. And the ICO's website now says that UK companies transferring data will need to use these UK specific clauses rather than using the new EU standard contractual clauses. So as if things weren't confusing enough already, once the new UK and EU standard contractual clauses have been approved, you could end up in a situation where you need to have both sets incorporated into one agreement to cover the transfer of UK and EU personal data to a data importer. Moving on to the next slide, and I just wanted to mention briefly Brexit, given that the Brexit transition period came to an end at the end of last year. In terms of its impact on data transfers, the position is essentially the same for companies in the UK. The UK has adopted the same adequacy decisions as the EU Commission for the time being, and also recognises EU member states as having in place an adequate level of protection so you can transfer data to them freely. As discussed, we're going to have new standard contractual clauses soon that we'll need to use. And then in terms of transfers going the other way, so from the EU to the UK, the Trade and Cooperation Agreement entered into between the UK and the EU effectively provided for an additional transitional period during which transfers could be made to the UK unrestricted. And that's going to expire at the end of June this year. But the good news is that the EU Commission has issued a draft adequacy decision in February this year in respect of the EU, and that's broadly been endorsed by the European Data Protection Board, and therefore there's reason to believe, and it's expected that the adequacy decision will be finalised before the end of June and the end of the transitional period, which is good news. I'll hand you over to Nigel now, who will be discussing eprivacy.
Thanks very much, Ben. So now we're going to look at the regulations relating to cookies. But first, why is it important? Well, first of all, as a result of changes brought in by the GDPR, it's no longer possible to rely on implied consent. You remember that many of the cookie banners rely on an implied consent, but just carry on browsing is consent. That's no longer possible following GDPR. It's also very high on the regulator's agenda in relation to cookies, because whilst I guess many of us don't really worry too much about cookies or suffer from cookie notice fatigue, just click through, there's an increasing number of complaints that are made to the regulators, nearly 2,000 in the past year. Also, the ICO is currently investigating the ad tech sector, which is largely driven by cookies. And whilst many of them are innocuous, others are highly privacy invasive, involving systematic monitoring and tracking across devices and so on. So they're concerned about the intrusive nature of much of this technology. Also, of course, because of the high level of GDPR fines, there's nothing like an eye-watering fine to bring a matter to the agenda. We've seen very substantial fines, for example, from the French regulator on Google and Amazon in relation to their use of cookies. 100 million in euros in the case of Google and 35 million in the case of Amazon. And finally, we've got the developing new law in relation to eprivacy, which I'll look at in a moment. So what is the law on cookies? Just a quick reminder of what it is. The current law is set out in the European eprivacy directive and in the UK regulations, electronic communications regulations, fondly known as PECA, Privacy and Electronic Communications Regulations. Actually, the law doesn't refer anywhere to the word cookies. It is the cookie regulation, but it doesn't use that word because it's trying to be technology neutral. Basically, the regulation covers any technology that can access or store data on a user device, whether that's a smartphone, smart TV, or any other device. And it also covers other technologies like tracking pixel GIFs, which are often used in email marketing to monitor whether emails have been opened, which can provide valuable analytics. So the key requirement under PECA is when you deploy a cookie, you must do two things. First of all, provide clear and comprehensive information about the purposes of the cookie. And also you must get consent of the user to use the cookie. There are a couple of important exceptions to this. The most important one for our purposes is a cookie that is what's called strictly necessary or essential for the service requested by the user. So cookies that are strictly necessary do not require consent. Cookies that are merely helpful or convenient or that are only essential for your purposes, as opposed to the users, will still require consent. So, for example, cookie used to authenticate a user or to remember items in a shopping basket or remember language or other preferences are regarded as strictly necessary, but cookies for analytical purposes and advertising are non-essential and need consent. So an important thing to bear in mind when looking at PECA as against the GDPR is that consent is needed for cookies, whether or not the cookie data involves personal data. So it may be completely anonymized and non-PII, but it still needs consent. If it involves personal data as well, such as device ID or username, browsing details, then it will be subject to GDPR as well. And under the GDPR, you always have to have a lawful basis for processing of data. Typically for marketing, that would be either consent or legitimate interests. But when it comes to cookies, where cookies are deployed and personal data is involved, then PECA effectively trumps GDPR, which means that if consent is required under PECA, then it is also the appropriate legal basis for processing under GDPR. So there's some debate about this in the ad tech sector, where many argue that whilst consent is needed for the initial cookie, it isn't necessarily needed for any subsequent processing of the same data. That could rely on legitimate interests. However, I have to say that at the moment, the regulator doesn't wholly agree with that. Although the actual legal position is not completely settled. So what do we need to do then in relation to cookies? The first thing is to carry out what's called a cookie audit to make sure you know exactly what cookies are in use on your site, what the purpose of each one is, and the duration. In this audit, you can identify any cookies that are strictly necessary, as we discussed, that don't need consent, and also any third-party cookies. In the case of third-party cookies such as Google Analytics or affiliate networks, while it is the third party that requires the consent, in practice, the third party requires that the site owner gets that consent on their behalf. So If you're operating a site that has third-party cookies, then in practice it's your obligation to get the consent for them. Review the consent mechanism you have on the site to make sure it's compliant. Everyone seems to do this differently. Some do it better than others, and some are more compliant than others. More on that in a minute. Good time to have a look again and update your cookie policy. Make sure that it meets the transparency requirement that we've discussed. And importantly, make sure that the policy is consistent with the cookies that are actually in use. There's no one-size-fits-all policy here. It all really depends on what cookies you've been implemented on your site and the purposes. And you may also need to carry out a DPIA impact assessment under the GDPR if the cookies involve personal data and are used for profiling or other similar purposes. And even if it's not strictly required under the GDPR, it might be good practice to do so to help manage any risks that may be identified. So how to get this consent? Because the consent required under PECA follows the GDPR standard, meaning that it has to be freely given, specific, informed, and an unambiguous indication of the end user's wishes through a clear affirmative action. So a couple of points on this. First of all, there's no need, as I've said, to get consent for strictly necessary cookies, and therefore there's no need for a pre-ticked box for that either. Where consent is needed, do not use a pre-ticked box because that would not be a valid consent. Consent has to be signified by a positive step such as ticking a box. And don't bundle multiple consents into one. Ideally, there should be a facility to give granular consents for each cookie or each category, and also an accept all or reject all option. The next one is important. Do not set the cookies before you've got the opt-in. So the cookies shouldn't be on by default, asking for an opt-in. They should be off by default and then only dropped when the consent has been given. So you might need to check with your technology team that they're operating correctly in that way. And then, as I said, provide clear and comprehensive information, because if the information is not clear and fully comprehensive, then it won't meet that transparency requirement, but it also will undermine the consent because that won't be fully informed. And also it's good practice then to have a facility for users to revisit the consents that they've given or perhaps come back and give consent. So there are some good models in that as well. Moving on to look briefly at the new eprivacy regulation, which has been knocking around for quite some time. It's been on the horizon since the GDPR came in. The idea was that it would come in at the same time. It addresses a number of issues, but the news is that the text has finally been agreed in February this year, and it is now going to the European Parliament, so it's expected to happen. The objective was to update the eprivacy directive, which is now 20 years old, and bring it in line with the GDPR. So it does align with the substantial fines under the GDPR, whereas at the moment fines under PECA are limited in the UK to £500,000. So there's a big difference there, but the end result will be that the fines are aligned. And also, like the GDPR, the new eprivacy regulation has extraterritorial application. So it will apply to all businesses outside of the EU insofar as it relates to users in the EU. But unlike the GDPR, it doesn't require those users to be specifically targeted. So that's quite a broad extraterritorial application, triggered as soon as you, for example, have cookies which implicate EU users, regardless of whether there's an intention to direct your activities at them. So far as the cookie requirement itself is concerned, there's not a huge change. There's still a need for affirmative consent, except the number of circumstances are a little bit broader where you don't need consent. It will extend to, for example, cookies for audience measuring or web analytics, or for IT security purposes, a little bit broader. The regulation is going to allow consent to be given by settings within the browser. So, for example, you could whitelist certain sites that you approve for cookies. Browsers may need to develop new facilities for that. And also, users who have given consent have to be reminded within 12 months, every 12 months, of their right to withdraw. So not huge changes in relation to cookies, but maybe some helpful developments. There are lots of other changes in the privacy regulation which are just outside of the scope, but something we'll look at on another occasion. And once the eprivacy regulation is brought in, there will be a 2-year transition period. So a bit like the GDPR, we'll have a bit of a warning time. But it's obviously good now, if you're not already comfortable, to make sure that you're compliant in terms of the way things are at the moment. As far as the UK is concerned, following Brexit, we won't in the UK automatically be subject to the privacy regulation, but I think it's quite likely that the UK government will make changes to PECA to broadly bring it in line with the privacy regulation, especially in relation to any more business-friendly sections. Also, because of the extraterritorial application of the regulation, which I mentioned, it's quite likely that many UK businesses will be directly subject to the privacy regulation anyway, because they will be addressing end users in the EU. So that's a bit of a lightning roundup of the regulation on cookies. And for our final slot, I'm now going to pass back to Ben, who's going to look at recent regulatory actions.
Thanks, Nigel. Yeah. So yeah, in this section, I'll be covering some of the main regulatory action taken by regulators in the EU and UK over the last year. So in terms of the UK, I'll be focusing on the fines issued by the ICO to British Airways, Marriott and Ticketmaster. And all three companies suffered quite serious data breaches at various points over the last few years. And those breaches resulted in quite significant amounts of customer data being compromised, and that included things like payment details. So that is why the ICO decided to take action against these companies. And as you can see on this slide, and over the course of 2019 and 2020, the ICO issued various notices of intention to fine the companies, which are essentially just preliminary fines. And under these preliminary fines, BA was to be fined around £183 million, Marriott around £99 million, and Ticketmaster £1.5 million. However, all three of the companies made representations to the ICO, and by the time the ICO handed out its final fines around the end of last year, you will see that the fines for Marriott and BA were reduced massively by around £163 million and £80 million respectively, whereas the proposed Ticketmaster fine was only reduced by £250,000. So why were the BA and Marriott fines reduced by so much and the Ticketmaster fine reduced by relatively little? Well, the main reason behind the deduction in the level of the fines for BA and Marriott was actually down to a change in the way that the ICO calculated the fines. So for the preliminary fines, the ICO had relied on a methodology set out in an internal document, and this methodology essentially provided for group turnover to be the key consideration for the ICO when setting fines under the GDPR. BA actually appealed against this and said it was unlawful, and the ICO actually conceded on that point and decided to depart from this methodology altogether when calculating the final fines issued against the companies. And that's notable because you can see with the Ticketmaster fine, which was the preliminary fine was issued in February 2020, And by that time, the ICO had already moved away from its sort of slightly dodgy methodology onto its new methodology, and that partially explains why the Ticketmaster preliminary fine was so much lower than the proposed BA and Marriott fines in the first place. So a lot of people sort of speculated that the pandemic may have played a major role in the ICO reducing its fines, especially given that all of those companies were hit very hard by the pandemic. And whilst it is true that the ICO did reduce its fines slightly for all of the companies due to the difficulties they faced by the pandemic, ultimately the amount it took off was only a relatively small percentage of the fines. And that suggests that companies shouldn't really expect too much leniency from the ICO during this time, unfortunately. The monetary penalty notices that were issued against the companies are all very long, but they all contain some very useful guidance that businesses would do well to take heed of. And some of the key takeaways, sorry, Jess, if you can just move on to the next slide. Yeah, some of the key takeaways from the monetary penalty notices include the importance of recognised security frameworks. So in all three penalty notices, the ICO frequently refers to guidance from various IT security institutes and bodies, including, for example, the National Cyber Security Centre and NIST. And therefore, we strongly recommend our clients to take account of these frameworks when putting in place their own security protocols and also when reviewing their security protocols. Another key takeaway is the importance of acting fast and cooperating with the ICO in the event of a breach. Both BA and Marriott had their fines reduced quite significantly, in part due to their speedy response to the breaches they suffered and also their cooperation with the ICO. This can be contrasted to the Ticketmaster response, which was slightly slow in the eyes of the ICO, and therefore they didn't have their fine reduced at all based on the speed of their response. Finally, an important point to note is that the principles, the GDPR's principles, might seem a bit high level and abstract, but they are actually important, and the ICO take these into account when issuing fines. And this is particularly important because if you fail to comply with the principles under GDPR, that actually attracts the highest level of fine under the GDPR. Finally, I just wanted to briefly touch on some regulatory action that's taken place in the EU over the past few months. And firstly, I wanted to mention the fine issued by the Irish Data Protection Commissioner against Twitter. So Twitter was fined €450,000 for failing to notify a data breach within the required timeframe set out under the GDPR. And this was essentially caused by its staff being away on Christmas holidays. And it meant that Twitter Ireland didn't report the breach until around 12 days after it should have been reported. The interesting thing about this fine is that the Irish DPC actually wanted to fine Twitter significantly less than the €450,000 sum landed on. But it had to cooperate with other supervisory authorities across the EU due to the sort of cross-border nature of the incident. So they were having to balance it against some of the German supervisory authorities that actually wanted to fine Twitter up to €22 million for the breach, which seems slightly excessive to me. But the fact that the DPC ultimately went a bit lower in its fine won't help its reputation of being a little bit of a soft touch to the big tech companies that are headquartered in Dublin. Similar to the Twitter fine, Booking was also fined €475,000 by the Data Protection Authority in April this year. And again, that was for failing to notify a data breach in time. In that case, Booking notified the regulator 22 days after they should have done under the GDPR. And another interesting fine that was only given out yesterday relates to the Canadian company LocateFamily.com. And this is a website that uploads individuals' contact details to its website, and often without individuals actually knowing that that's happened. It was fined €525,000 yesterday by the Dutch DPA, and the Dutch that was for failing to appoint an EU representative under Article 27 of the GDPR, which the Dutch DPA said it made it difficult for individuals to get their details removed from the site. So these fines they follow a bit of a familiar format. We also had the Spanish Data Protection Authority in the last year handing out various fines for companies that failed to appoint a DPO. And it follows a bit of a trend where we've seen regulators in the EU impose financial penalties to companies that you would normally consider are relatively minor procedural matters. And that can be contrasted against the position in the UK, where it still seems like the UK, the ICO is slightly reluctant to impose significant fines under the GDPR for matters other than quite significant data breaches. So that kind of wraps up the presentation. We've got a few minutes for questions, so I'll hand over to Nigel in case take the lead on that.
Thanks very much, Ben. And we've got quite a few questions that have come in on the chat, and I think we've answered a few of them as we've been going along. We've just got a couple of minutes. If I can just raise a couple, one with Kolvin, one with Ben, and time one with myself. Kolvin, a question from Laura. If we collect vaccination data anonymously, do the issues raised still exist? Presumably because it wouldn't be personal data at that point.
Yeah, I did answer that on the chat, but I think in short, in theory, yes. So I think if the data is truly anonymous, then it takes it outside of the realms of the GDPR. I think the difficulty is that the standard around what is anonymous data is very high. So it's not enough to remove, identifiers or pseudonymize the data. So if you're still able to identify who has submitted the vaccination record in some way, then it's still going to be personal data. So I think it would really depend on exactly how you anonymize the data, and I'm trying to think how you would how you would do that in the context of employees submitting vaccination records. And I still think, even if there is some way to kind of anonymize the data, I think you still need to explain to employees, why you want it. So I think you'd still want to articulate a clear need, and I think that might be hard to do in the context of anonymous vaccination data. It's sort of like, well, why would you need that? And I think if you can explain that, I think that's a good thing. But yeah, I think in short, it's very hard, I think, to anonymize data. If it's still pseudonymous in some way, that's you'll still need to treat it as personal information.
Great. Thanks, Kolvin. A quick one for Ben from Federica. Will the UK SCCs invalidate the EU SCCs?
Yes, so I think I touched on that during the presentation. So for UK transfers, the ICO has said that you will need to rely on the new UK SCCs going forward. So they won't invalidate, if you're currently relying on the existing EU SCCs to transfer data, you will need to transition over to the new UK SCCs. So yeah, effectively they will.
Yeah, it doesn't get any clearer, does it? They don't make it easy. Just last question, which I'll take from Martin. An increasing number of cookie notices now provide the ability to opt out of legitimate interest cookies. Is this relevant for UK businesses, or does this relate to non-EU UK legislation? I think this may be an example of one of the many sort of cookie notices which is not valid or compliant with PECA, because to have a cookie, as I said, you have to have consent, and you can't rely on legitimate interests for cookies. You may arguably be able to rely on legitimate interests for subsequent processing of the information, but that's a bit debatable. But to have legitimate interests for cookies on an opt-out basis doesn't sound like it's compliant. And I wouldn't be aware that it's for any other non-EU legislation, but it wouldn't comply with UK EU. So just checking the time, and I want to thank my colleagues Ben and Kolvin for their excellent presentations. I think we've used our time, so I'm going to draw this to a close. But please do follow up with us if you have any additional questions or need help with any of the topics that we've discussed or related issues. So from Kolvin, Ben and myself, thank you again for joining us, and we look forward to seeing you again soon. Thank you.